There we go.
Okay, folks, it's a little after 8 o'clock Eastern Standard Time. Our typical drill is we wait about 4 or 5 minutes before we get started. But we do have our team here answering questions, so fire up the Q&A and we will start answering your questions. I don't think we're going to go long today because we have a fairly limited agenda. So just hang in there. We'll get started in a few minutes.
John, since we're killing time, how are you doing?
I'm good. I've been busy. Life has gotten busy, and I'm not a fan of daylight savings.
It's really interesting. You point that out. I read about daylight savings, and it's there's bills in Congress to do away with it. So I hope they go see the light of day. See that I made a joke there. See the light of day.
Yeah, it's funny. I was driving through the country the other day, and uh, all the combines were out there with their headlights and spotlights, and so the whole notion that we need lighter later so we can get the crops out of the field, I guess doesn't really apply anymore. Okay, folks, we're closing in on about 8:02. We've got a bunch of folks on. We had close to 2,000 in our last town hall, so we might back up a little bit tonight and talk a little bit about TCC, and we'll give an update, but we'll get started here in just a few minutes.
These are good questions. When everybody asks questions, it helps direct a little bit of our conversation
Yeah.
later on. So please chime in if you have any questions and you want things for us to address. If we see enough of the same question, we might not address each one individually because we'll chat about sort of all of them later on.
We're going to wait about another minute before we get started. But as you guys can see, we're already answering questions as they're coming in. Some really good questions tonight, some of which we're going to cover. I think Jim's going to talk about the hearing tomorrow, so we'll get to that. This fear tactic about going into 5 to 10 years of litigation, we're going to talk a little bit about that. And then we're going to...
we'll give a local counsel dashboard update as well. So yeah, John, I think you're right. I think this is a good week for everybody just to say, here's kind of where we are on what is today, November the 11th, a little bit of an update.
Around the corner.
Yep.
Okay, what do you say we go ahead and get started, Doug? I think the numbers have slowed a little bit. Good evening, everybody. My name is John Humphrey. An announcement many people won't know about, but the committee voted this week to make Doug co-chairman, which I'm really excited about. He's been an awesome advocate for you guys for almost 2 years now. And, the committee just thought, maybe they're going to take me out. I don't know, but it was a great honor. So welcome my co-chairman, Doug Kennedy, Dr. Doug.
Thank you, John. I didn't know you were going to say anything about that. I don't do well with recognition, so so thank you. And I just want to say how wonderful it's been working with you and the other 7 members of the TCC. This is the most amazing group I've ever been involved with. And for those of you who are tuning in for the first time, we're 7 survivors. We were interviewed along with 100 other survivors and got chosen to be your advocates, the 9 of us in this bankruptcy. And we are volunteers. So we don't get an award until everybody gets an award, and it is an incredible group, and these gentlemen make decisions that are the best for all of us. And sometimes they've had to make decisions that maybe weren't in their best interest individually, but there was for everybody. So I'm happy to be a part of this group, whatever function that is. And John, I want to talk a little bit later about some of the email that we've gotten too from all the survivors as well.
Great. So look, guys, we've been up to our necks in this stuff, and we're not trained professionals. We're not attorneys. We've learned more about bankruptcy than we ever wanted to know, and the other 7 members have as well. We do have one retired attorney on the committee, so we go to him on some legal matters when we're talking amongst ourselves. But the TCC was appointed by the U.S. trustee, the Department of Justice, and our mission is to represent all 82,500 survivors. And we think it is in the best interest of all survivors if we vote no on this plan, if we reject it. And I just want to review this before I turn it over to Doug and Jim. So, we want 3 things. We think it's important to have some independence and oversight around youth protection. There's a lot of discussion about a special committee that's being put together, but the things that we've read don't provide for independent expert oversight. And we think that actually is a very good thing for the Boy Scouts. We think it could be a marketing benefit. And let's not forget that since youth protection went into place, 18,000 of the 82,500 survivors have happened since youth protection. So, it's not a great track record, and we just think it would help the Boy Scouts to eliminate sexual abuse. And we just feel that is a non-negotiable, and so we're going to keep standing on that one. The second area is dollars. If you took any of your cases into the state court where you have a good statute of limitations, your awards would be substantial. And the way that the other side is characterizing the amount of money that's available and how it will be divided up, it's not enough. And we know this because we hired some extraordinarily good coverage counsel, insurance coverage counsel. And, we think that there's hundreds of millions of dollars worth of coverage and billions in responsibility for some of the large insurers.
Yeah. Hey, John.
Yes.
I just wanted to say one thing, though. Not every single claim out there, just because you could bring it in court, is necessarily going to get something.
Yep.
All claims have sort of different facts, and there are different laws in different states in the enforceability of those claims. And so it depends. And so just the fact that somebody could bring it doesn't necessarily mean that they're going to get some big award. That just wanted to sort of temper
this. This is why we have professionals, because you're absolutely right, John. Thanks for that clarification. So that's number 2. And we think there is the ability for these insurance companies and sponsoring organizations to come to the table with more dollars. And that means that, everybody benefits. And then the last thing is the way that the trust is administered, the independence. We've been betrayed and abused and lied to, and that creates a lot of suspicion on when people say things. Are their actions consistent with their words? And when it comes to putting billions of dollars into a trust, we think that we should have an independent trustee, not a trustee that's worked with, other lawyers before. We think the procedures called the trust distribution procedures can be improved substantially to bring more pressure on the insurers. So we're standing on those 3 pillars. Honestly, folks, I don't think we're that far apart from where the current plan is. And one of the things that really gets stuck in my craw is when I hear this nonsense about, 5 to 10 years of litigation if we reject the plan. The votes are due by the 14th of December. We will get a report on the 27th of December. The confirmation hearing is on the 24th of January. Now, I haven't heard this from the judge, but the way this judge has acted since the beginning, she will force us, no matter what, into mediation. And we will probably have a resolution, regardless of how things turn out, by the confirmation hearing. So this is not going to go on for years. A reject vote means that we negotiate a better deal and get more. So with that, I'm going to turn it over to Doug, and he's going to ask Jim some questions, and we'll go from there.
Sure, John. I'm wondering if maybe what I should talk about is, before we get to Jim, and kind of the update for this week, just chat a little bit about voting. What do you think?
Yeah, let's do that.
I think everybody right now, this is all about voting. This is really all about the TCC just trying to get the facts out to all of you, to update you each week on what's going on, but it's really about voting. And the TCC really understands that as survivors, we have been powerless for a long time. We were powerless against our abusers. We were powerless to deal with this legally. We were powerless to do anything for so long. And now that we're in bankruptcy, and now that this is out for a vote, now's the time for survivors to exercise their power by voting. So we've really been focused on how to help survivors vote. And as this goes on, we're going to continue to sort of revise our focus a little bit as we hear about any problems or issues. So I just want to talk about a couple things. One is, we heard from a number of survivors who said, I received the ballot, and how do I fill this thing out? What do I return? And first, let me tell you, the TCC, as John mentioned, recommends that this settlement be rejected. But you have to make your own mind up individually. And we really respect the rights of every single survivor individually. So if we believe, the TCC, that this plan should be rejected, but in your heart of hearts, if you want to vote to accept it, then you need to do that. And we want to help you just as much cast your ballot. So what John Lucas and I did in the last week was we just sat down. It's very low tech. We put together about a 15-minute video that if you have a paper ballot, then this is essentially how you would fill out the ballot, the boxes you have to check, where you have to sign it, what portions you put back in the envelope and send back. Also, you can upload it as well. So that's on the website, tccbsa.com, and we'll continue to update that website. Also, there's a button on that website if you want to request a ballot as well. So we want to help people just feel good about, I have a ballot, I've signed the right things and sent it back. So that's the first portion. The other portion is, what we're hearing from a lot of survivors is they want to have some degree of kind of validation. Was my ballot received? Was it recorded the right way? I told my attorney how to vote. Was that recorded the right way? And what we understand so far is that there does not need to be a system in place to validate your vote. So in other words, there's no way for me as an individual to look up online and see my ballot was received and here's how it was cast. We know that survivors want the opportunity to do that. And our professionals are communicating with Omni, the people that are recording all this, to see if there's some way we can work through that. So we've received a lot of letters from people saying, I returned my ballot. How do I find out whether or not they got it and all that? We hear you, and we're doing what we can to advocate for survivors for that process. The other piece of this is, for those of you that are represented by attorney, I have an attorney and my attorney has communicated with me. It's my responsibility to make sure that my attorney has received the way I want to vote and understands that, and that communication was done properly. So the TCC, we can't call up your attorney and say, hey, did you get John Humphrey's ballot and he wanted to reject it? Do you have it written down? As a survivor, as an individual, you have to work with your attorney on that. The last piece of this is, there's been some questions where people have said, what about if I have voted through my attorney, or what if I've changed my mind? Can I get a ballot and then vote again? Or, how does that work? And the answer is yes. You can go ahead and request a ballot from Omni, and it's going to take a while. We've heard from people now that have waited a week, 10 days. So it's going to take a while, and they're kind of slammed right now. But you can go ahead and get a paper ballot from them, email them, they'll send it to you. It'll have your claim number on there. And then when you vote, that ballot will supersede anything else that was cast. So if I vote this week and then change my mind and return a ballot in a couple of weeks, that's the last one they get, is the one that will count. So again, right now, everyone, this is about voting. We want to make sure that the court understands the will of survivors. Yes, the TCC believes that this vote should be rejected, but more than anything else, we just want survivors to vote, because this is your chance to have some degree of power in how this comes out. So I'm now going to turn this to Jim. Jim, I hope I said that all correctly, especially the kind of Omni validation piece of it.
So let me just comment on that. We have not actually contacted the debtors yet about the issues of validating the vote. And when I share with you, Doug, validation means the ability of a survivor to confirm that the vote he or she cast was accurately recorded in what's going to be called the voting report. We've talked about it internally. It is my intention to talk to debtors counsel about that, but I don't want anyone to feel like there have been deaf ears yet, because frankly, we haven't presented it to them specifically. So I think that would be the only thing that I would mention. About Omni. I've heard some reports that they deliver ballots within half an hour of being contacted. And then I've heard stories, they're secondhand, that it's taking longer. I would hope that survivors are not discouraged if they don't get their ballot within half an hour of asking for it. Please, hang in there. If you don't get it within a reasonable time, which might be a day or two, contact them again. And if you're not getting it, call your lawyer and have your lawyer push on them to get you the ballot. If you don't have a lawyer, or contact us, and we'll alert Omni to any problem. But we don't want to interfere in your relationship with your attorney. And so if you have one, this is partly why you retain them. Ask them to help you out.
Jim, thanks, Jim. And one thing I want to add to that is, again, please vote. But also, please don't wait until the last second, because this has to be received by Omni by December 14th. And please don't wait until the 13th to send that out. So now is my turn to kick this to Jim to say, so Jim, since last Thursday, what's been going on in bankruptcy world, settlement world?
Well, the biggest thing that's going on is the amount of discovery that's being issued by the different parties in the case. And by different parties, I mean the debtor, the future claims rep, the coalition, us, the Church of Jesus Christ of Latter-day Saints, and there's a committee made up of Catholic and Methodist chartered organizations. That committee is issuing discovery. And then there's just a boatload of insurance companies that are issuing discovery. So what do I mean by discovery? Well, the first part of this was, and there's a schedule that the Bankruptcy Code has set, that the Bankruptcy Court has set for how this discovery rolls out. So the first thing was sending out requests for production of documents. And those requests were issued, sometimes I'll use the word propounded, that's the lawyer talk for it. What it really means is that someone sent a request, and that they tend to be somewhat formulaic in terms of definitions and rules, but it can have, send me every email you ever sent regarding John Humphrey. Send me every document that you've ever had regarding this insurance policy or that insurance policy. So those requests go out, and that deadline for getting those requests out was, I feel like, about 2 weeks ago, maybe a little longer. And then everyone had an opportunity to say yes or hell no. There were a lot of hell no's, and those are objections to requests for production of documents. And so we have had, and our friends who are on answering some of your questions, Steve Golden and Malhar Begay, have, and a host of other people from my law firm and from the Passage Law Firm, have been meeting with the other sides to try to narrow our differences on what documents should be produced and which documents shouldn't be produced. Why shouldn't a document be produced? Well, it was a communication with your attorney. That shouldn't be produced. And there are a couple of other things that we call privileges that would protect the or protect people from having to produce certain things. So as all that was going on, there was a deadline of, I believe it was last Friday, to substantially complete the production. Well, just to give you a sense of the magnitude of this, the Boy Scouts have produced over 1 million pages of documents. Some people, and yeah, it's understandable, you know, they're the main focus of the bankruptcy and they should be producing the most documents. You have some insurance companies that are producing a lot of documents, and you have some insurance companies producing very few documents. For the TCC side, our initial arms around the documents, because you have to search your emails and text messages, we initially pulled over 600, almost 640,000 documents that we thought at a very big net we had to look at. It was over 6 million pages. Now, we don't have someone sitting there turning the pages, but there are all sorts of search terms you can use to narrow down that number. And at the end of the day, well, not Friday, but we produced some things on Friday. We produced some things this week. We have produced approximately, this is a day or two old, folks, 6,400 documents for about 56,000 pages. And there's ongoing discussions with people about making sure the productions are as complete as possible. Some people, including us, are writing letters to the judge, which is how she wants us to handle it in terms of process. And those letters are, I believe, filed with on the docket, saying, hey, Judge, we've met and conferred as much as we can. We can't get an agreement on the production of this kind of category of documents. Would you please tell us what you think about the legal dispute and whether they should or should not be produced? So that's going on. Meanwhile, deposition notices are starting to go out. There are, last I counted, which was a day or two ago, 125 deposition notices have been issued. Now, 3 people might all want to depose someone at the Boy Scouts. And so there's some double counting there, but over 50 people have been designated to have to give depositions. So the request for depositions kind of overlap because 4 or 5 people might want to talk to the same person. But in terms of potential witnesses, it's over 50. And from a lawyer's perspective, you don't want to walk into a deposition. And a deposition is a question and answer under oath. You don't want to walk into a deposition without having read the documents. And so the process of simply uploading 1 million pages to a computer database that can then be used to refine and search terms like insurance coverage or insurance limits. You put those words in and the computer spits out 30,000 documents or 30,000 pages that have that term in it. I mean, that's how this works in this day and age. But as you can imagine, that is a lot of stuff to go through with a deposition deadline of December 1st. That's when what we call fact discovery has to end. Now, there's been a little move into that. Some people are going to be done on December 2nd or December 3rd. But early December is the current deadline for getting these depositions, not just noticed out, but completed. I mean, just think about that with Thanksgiving intervening. And then once the fact depositions are done, we have what's called expert discovery. So in a couple of days, we meaning everyone in the case, is going to have to designate who is going to testify as an expert in the case. From our side, that's going to be a company called Berkeley Research Group. You hear them referred to occasionally as BRG. Those are our financial advisors. They're going to be testifying about a range of issues that will be described in the notice that will be filed in a few days. We retained a group called the Claro Group, C-L-A-R-O. They're going to testify about the value of the abuse claims, because everyone's talking about how much they are. The Boy Scouts say it's between $2 and $7 billion. The future claims rep says, I think it's upwards of $25 billion. People are talking about how much cents on the dollar you're going to get. Well, you don't know that number or that percentage unless you know how much the claims are. So we have an expert there. There will be other experts. The Boy Scouts will have experts, possibly the coalition will have experts. I mean, we won't know until we see the designations of the experts in a few days. And if you thought we were done, there's then the expert report. And then the experts can be deposed over the expert report. And then, of course, everyone gets to respond with their experts to the other guy's or person's expert report. So this is all leading to a day of January 24th, when the confirmation hearing is scheduled to start. As I've said before, we don't know if that's going to be the 24th, 25th, 26th. Sometimes in courts, you skip a day because Judge Silverstein does have a few other things to do. But we'll find out as the case develops, as we get closer to the date, how she intends to actually conduct the hearing. Will it be live in Delaware? We don't know. The Delaware court is used to big cases, used to a lot of people coming to hearings. But if the attendance on these town halls is any indication of people who would want to come in and see the hearing, we're going to have to, or I should say the debtor is going to have to figure out how to accommodate everybody. So welcome to discovery. The second thing that's happened is that we've had some issues regarding TCC communications brought to the court's attention. There have been some complaints about the TCC communications. There's a hearing tomorrow about it in front of Judge Silverstein. There's another hearing scheduled about it on Wednesday next week. And because we have an upcoming hearing, I don't want to get into the details of it, but that's going on. Mediation. There are 2 mediation days scheduled, because if you're not conducting discovery, you should be mediating. And we have enough people to cover this, but it's obviously a lot of work. There are 2 mediation days, the 15th and the 16th. They're done, I think it's going to be in New York. There's going to be a hybrid Zoom opportunity, and we'll go to those mediations. We'll be in attendance by Zoom or in person. Settlement discussions. Settlement discussions are by definition confidential. The mediators are working to try to get people to resolve differences with existing settlements. The Hartford settlement, the settlement with the Church of Jesus Christ of Latter-day Saints. And there are, as we all know, a host of other insurance companies and parties that could be the subject of settlements, but where settlements have not yet been achieved. So that's what's going on.
Okay, thanks, Jim. Appreciate it. Let's see, we've covered voting. We've covered the video on the TCC BSA website on how to vote. That was a really good video, John and Doug. I thought it was very informative. I looked at it. I think we're here. Any themes on the questions? Because I think, we've still got quite a bit of time, and I think we should focus on Q&A just to get people's questions answered.
Yeah, I want to put one plug in, and that is that video that we did. We're seeing some mechanics questions about voting, and the video that we did, again, it's on right on the homepage. I think the button is how to fill out and return the ballot. Really walks through the page numbers, the things you have to check off, what you fill out and return. So if you have a ballot and you're a little bit intimidated by that, it really runs through it step by step. Or if you're having trouble falling asleep at night, it's probably also a good video to watch, but it really falls through step by step. But one question I wanted to ask, and I think this is, I know this is a lawyer question, Jim and John. The question's about the opt-out. And can you explain what that means to people? The one question about whether or not you want to opt out of the releases.
Yeah, I'm going to ask John to answer that because when I interrupted him in the last town hall, I got it wrong. So, John, would you take a stab at it?
And so if you look in the ballot, and when you're in this section that's talking about the opt-out section, there's a footnote that defines who the released parties are. And so these are individual claims that survivors and whoever here is voting under the plan could have, might have against these parties. And you're not required to release them, and you may opt out, and you very well might not have any claims against these parties. And so the way that this plan works is that they're not requiring you to give them up. They have to ask you. And I think the bottom line is if you do not know if you have any such claims, then opt out. It doesn't affect your overall claim. And to be clear, this isn't about your sexual abuse claims that you have against the Boy Scouts or a local council or a chartered organization. These are other claims, independent claims that you might have against those released parties. There's something wholly separate and different. And so you're probably scratching your head and saying, well, I don't know if I have any such claims. Then my recommendation is opt out.
And John, you opt out by checking the box or by leaving it blank?
You opt out by checking the box. And there have been other questions people have asked, well, I don't want to do the $3,500 expedited distribution. What do I do? And the answer to that question is you leave it blank. You just do nothing. You don't touch it. You don't check it. You don't say no. You just leave it blank.
But John, I've also heard the question, I don't like the plan. I'm going to vote no. If I vote no, do I forfeit my ability to get $3,500 if in fact the plan is confirmed? And so I wanted people to know that if you reject the plan, you do that on whatever page it is of the ballot, you turn a page or two, and the next question is, do you want the $3,500? You can vote no and still say, I'd like the $3,500 if the plan is confirmed. You have the opportunity, you can of course say accept and take the $3,500. You can say accept and not take the $3,500. You can say reject and take the $3,500, or you could say reject and not take the $3,500. The $3,500 does not affect your yes or no vote on the plan. John, I hope I got that right.
You did.
Thank you.
John, you want me to say one or two things about youth protection?
Sure.
Yeah.
Why don't you be specific about what we're looking for?
Yeah, and I have to tell you, we've received so many messages from survivors that have said more than anything else, I want to vote for a plan that I'm sure is going to stop the abuse, that I can have confidence that when this is over, the abuse won't continue. And the number of people that have written to us and said, this isn't a 1 year, a 3 year, a 5 year problem. This has been going on, and we want to have some assurance that, after we're gone, our grandchildren, are going to be protected. And it's really been heartwarming to this TCC, the number of people. And I think, quite frankly, a lot of people underestimated how important this was to survivors, but we know how important it is to survivors. So the TCC has stood all along for a plan that is strong enough, one that has an independent body that will have oversight as part of the Boy Scouts, one that will be able to validate data each year, will be able to communicate the data if there's any abuse nationally and also at the local council level. Data that will be transparent and reported to the public so that people know whether or not their children are safe. We want those reports to be available and submitted to Congress because, you know, the Boy Scouts report to Congress every year because they get a charter. So we wanted there to be transparency there. And more than anything, we wanted there to be experts really informing the Boy Scouts of what needed to change, and then the public knowing what changes the Boy Scouts have made, as well as what changes they refuse to make as well. So we just believe that this current settlement is woefully weak when it comes to youth protection, and the TCC is not confident that this abuse is going to be eliminated at this time. And we're standing hard on that, really, really hard on that, because this is our one shot to get this right at this point. So that's where we are on youth protection. And we're hoping when this settlement is voted down, that we'll be able to go back to the table and said, you need to listen to survivors and we need to strengthen this.
John, I was looking at the Q&A and I saw a couple of questions that I wanted to address.
Be great.
One of the questions is, where are you getting this 10 cents on the dollar stuff? We have said in pleadings and in court, I think we said it, well, we certainly have said, I'm not sure exactly where we said it, that you're going to get 10 cents on the dollar. Well, where do we come up with that? It's in the disclosure statement, but that's obviously a tough document to get through. I want to make really clear here that that number is based on two things. First, the current settlements, not the settlements that, and we're assuming those settlements for the purposes of our presentation will be approved by the court and that they will be paid. So we take that as the number less certain costs for the trust that's going to be distributed to survivors. But then we have to, because it's a percentage of something, right? So what is the of something? How do we compute the amount of the claims so we can figure out the percentage? We took the claims, we have access to them. We took the trust distribution procedures that are in the plan. We used the base amount for each category of abuse. And for the states where the statute of limitations is not open, like California or New York was, or some other states, there was a range. There's a range in the trust distribution procedures. Some states, the discount will be 0 to 10%. We took the middle of that and we computed all that together and came up with a dollar amount of the claims. And so we took the amount of the current settlements, as divided it into the value of the claims as we calculated it in the TDP. And we have concluded that based on current settlements, it's about 10 cents on the dollar. Now, that number is affected by a couple of things. One is people taking $3,500 who might otherwise get more under the TDP. But for personal reasons, and I'm sorry, folks, I'm getting even fuzzier and fuzzier on this screen. I can't explain why my camera's doing that to me. But you know, if for people take $3,500 and they might otherwise get a larger dollar amount, but for personal reasons, they don't want to go through the effort, don't want to take the time, you know, that of course could affect how much is in the pot and how much the claims are. There could be more settlements. And I saw someone say that I think it was whatever, was it yesterday, the court hearing, or the day before, about settlements soon coming. Miss Loria, who represents the Boy Scouts, said there was going to be a breakthrough announcement. And I took that to mean soon. I'm not sure if she said soon, but I don't think you tell a judge that something's about to have a breakthrough moment if it's not going to happen soon. And so did I put words in her mouth about the timing of it? I didn't mean to, but that's how I interpreted her comment. There has been no announcement of another settlement. I don't know if it's imminent. I don't know if it's going to be 3 weeks from now. I was just going off what the Boy Scouts attorney said to the judge at the last hearing. So I saw those questions and I wanted to just comment on them, John.
Thanks, Jim. All right. Any other themes?
Yeah, I have something. So somebody sort of put something in here and said, you know, there's 1.6 to like 1.8 billion for the current claims, but the future claims are going to get 5 billion. And they said, you know, that isn't correct. How is that right? And so that's sort of just factually inaccurate. Right now, under the plan, as Jim just said, there's about 1.8 billion that's in the pot, that's slated to be in the pot. And, after you take out the operating expenses, maybe there's, 1.6 or so, and there's some of it is earmarked for TCJC claims. But the future claims representative in the disclosure statement has stated that the future claims, and there are about 11,000 of them they estimate, are worth $5 billion. That's their view of what they're worth. But if the plan only has so much money, they're only going to get a fraction of what they're worth. And that's what Jim was trying to explain. And so just because the future claims are estimated to be worth $5 billion, that doesn't mean that they're going to receive that amount. It just depends on how much money's in the trust.
And one other thing, someone's asked, well, you all say it's 10%. The plan says it could be 63%. How do I jive those things? The amount that's coming into the settlement trust under the existing deals, folks, not the ones that might be a breakthrough moment tomorrow. That's a fixed amount. We all know what that dollar amount is. The variable is the value of the claims. The Boy Scouts say that the claims are worth between $2 and $7 billion. Well, obviously the percentage changes. If it's 2 billion, the percentage on the dollar is going to be much higher than if the claims are 7. The FCR says, and I hope I'm getting this right, that the claims are approximately $25 billion. Almost 4 times the amount the Boy Scouts have at their upper end. Well, if the FCR is right, obviously the percentage goes down because the amount of the settlements is fixed right now. And if we use the TDPs, this is not our independent valuation of these claims, folks. We have gone to the TDPs that have been presented by the debtor and the coalition. We have used the base amount for each of the categories of abuse. We have discounted it by the middle of the range of any states where there's a middle of the range stated, and we came up with a number. And so we're not putting our thumb on the scale here. But that's why the percentages are different. It's because people have different views as to what the value of the claims would be. If you took the Boy Scout percentage at 7 billion and they added some more settlement money, the percentage is going to go up. Now, is that an adequate settlement, the breakthrough settlement? And I don't know what it is. I have not any idea from any reliable information as to what that settlement is or who it's with. But it may be an adequate settlement. It may not be an adequate settlement, but it will drive a different percentage. The question is it driving it high enough? Is it enough money? That's the issue. So I know we're doing a little math here. It was not my best subject in school, but this is basically percentages that are going to change based on whether the settlement value goes up or the dollar of the claims is finally determined to be X.
Jim, we continue to get this question almost every town hall about unhappy with my current counsel. What can I do? I know it's a very sensitive subject. What are people's rights, I guess?
So I don't know which lawyers are making people happy and what making people unhappy. So this is absolutely without regard to any particular law firm. If you have come to a decision that your lawyer should be replaced, you have the absolute right to do that. You may have signed a retainer agreement. Well, presumably you signed a retainer agreement, but there's not a state in the country where you as the client are obligated to keep that attorney. So if you want to terminate your relationship, I would look at the retainer agreement. I would look to see if it has any provisions regarding termination of the relationship. If you can't find the retainer agreement, contact your lawyer, because at least it would be my practice, and maybe it's required by law, that they have to give you a copy of it if you can't put your hands on it. So look at the retainer agreement, see what it says about how one terminates the relationship. I don't want to, because I don't have anyone's particular retainer agreement in front of me. You basically tell them, and I would do it always in writing, of course, that you want to terminate the relationship. You are entitled to a copy of your file. At least you would be in California. And I'm sure you are practically in every state. And then you can go find another lawyer. And so the question is, hey, I signed a, say, let's just call it a 33% contingency with lawyer number one. Lawyer number two wants a 33% contingency. Did I just spend 66% of my recovery? And the answer is, should be no. But for the replacement lawyer you're talking to, if you're intending to hire another lawyer, you should talk to them about how it works, because usually it ends up getting addressed by the two law firms. Not necessarily always worked out, but addressed. If you decide you're going to go it alone, then at the time there's going to be a distribution, undoubtedly your now terminated lawyer is going to say, you owe me a fee, and there'll have to be some process by which that's determined. Your local state bar association has rules about this sort of thing and how these kinds of claims disputes can be addressed. You might have to hire a lawyer to address the claim of the first lawyer to a full contingency. So it's not hard to do, but it has consequences that do require you to look at your retainer agreement and consult with someone regarding the rights if you hire someone to replace the lawyer, or what your rights are if you decide to go it alone. But you have the right to terminate the relationship.
Okay, we've getting close to about almost 200 questions answered. 746. I'm looking for other themes. There's a good question about if there's some kind of a settlement coming, why should I vote now? Either way, that settlement would be announced by the other side, and it would probably be less than we would be satisfied with. And
well,
so,
I think the other piece of that too, John, is even the money that's been agreed upon right now isn't going to get us to what the TCC thinks is going to be appropriate as well.
yeah. Yep.
So this issue of we've got this kind of moving target, and how do I know what I'm supposed to be doing? That's not. How do I know where my interests are, given that there's a moving target? And the answer is, I'm sorry, but there is a claims deadline. I mean, I'm sorry, a voting deadline. It's December 14th. And, we don't make settlements with anybody. The settlements are with the Boy Scouts. And we get to be heard on that in court. We try to participate in mediations. And obviously there are other players, the coalition, the future claims rep. I would hope that if there are settlements essentially in hand, that people are told about them as soon as possible. And people can kind of recalibrate and figure out if they still want to vote yet. Well, presumably they voted yes for the existing ones there. They're going to vote yes. Well, they might change their minds if they think it's a really low ball settlement. But anyway, the point is you can recalibrate, you can figure out what you want to do, but it has to be done before December 14th. And if those settlements come after, but before January 24th, the confirmation hearing, people might contend, and we might be that group, maybe not, that judge, you shouldn't conduct the hearing on January 24th. There's been such a big change in the playing field that creditors need a chance to evaluate that. Revote? Maybe, maybe not. Be heard on whether the settlement should be approved. I mean, if a settlement's approved, is announced on January 23rd, and the confirmation hearing starts on January 24th, and that is a material, significant, important settlement, I think the judge is going to have to grapple with whether she should go forward. But it's not under our control, because at the end of the day, these settlements are between the Boy Scouts and the other side, and whoever's on the other side of that settlement.
So Jim, in the time that we have left, we're all so fixated on this vote. So maybe you could go back to the 10,000 foot view and talk about how a plan gets confirmed, what the judge can and cannot do, what some of the legal arguments are that we and others might be making, because it's not just binary, yes and no, and things happen. And
Right.
I think that's getting lost on people. So,
okay. So first, let me start with the voting concept. There are probably 15 or I don't know, 15, 16, 17 different things the court has to check to confirm a plan. For example, the court has to find that the plan was filed in good faith. The court has to find that the plan complies with applicable laws. One of the things the court looks at is the vote. And voting, the outcome of the vote can have a very significant impact on those other boxes she has to check when there's discretion involved. So for example, well, first let me talk about the vote itself. It's based on the people voting. It's not based on how many creditors there are. If only one person voted and they voted to reject, the plan is rejected by the survivors. It's the number of people voting. So that's really, really important to know. The second thing is everyone's vote in the survivor class is equal. The court, for purposes of calculating the voting, has given everyone a $1 vote. Why did the court feel the need to assign a dollar amount? Because in a conventional bankruptcy, the voting margin is determined by how many people have voted yes and how many dollars have voted yes. But because practically no one in the class of survivors has an actual judgment against the Boy Scouts, the way of dealing with that, especially when you have 83,000 people, is to give everyone a dollar. So in order for the plan to be approved with all of the settlements that are involved here, which is not just the Boy Scout reorganization, but this plan deals with the claims against local councils who are not in bankruptcy. This plan deals with claims against chartered organizations who are not in bankruptcy. This plan deals with some insurance issues that are what I'll call extraordinary. And so because there are all these other settlements with non-bankrupt entities involved here, the percentage of people voting yes, in our opinion, has to be no less than 75%. Now, if this were just the Boy Scouts proposing a reorganization without all those other bell and whistle settlements, it's 2/3 of the survivors. But because it's got these extra elements that involve entities other than the Boy Scouts, entities that have not filed bankruptcy, I mean, it's the conventional judgment of bankruptcy lawyers that it has to be at least 75%. Now, if it's 76%, is it thumbs up? Not necessarily. The court is looking for whether there is, these are my terms, but it's what I believe the law is, overwhelming support from survivors. Now, if this were a case involving asbestos, 75% is the margin that's necessary. But this is not an asbestos case. So we're kind of in the world of analogies. And so people like to talk about 75% as if that's the magic number. It is not, but I do think it's the floor for approval of this plan. Now, other things the court's looking at. As I said, good faith, complying with applicable law, that the management of the Boy Scouts meets a certain satisfactory standard. I can't remember the exact terms, but the court will review the management of the Boy Scouts to be sure that it's satisfies the requirements of the bankruptcy code. The court will be looking at whether the Boy Scouts are going to have to file what we call a Chapter 22. Is there financial feasibility to their plan? They have X dollars going forward. They have membership projections. They have dollar projections. They have their expenses. Is it financially feasible given what they have proposed? But probably the most important thing, and this really goes to the heart of what a lot of people are hearing about, is whether there's enough money coming to the settlement trust. Yeah. When the local councils are getting released of their liability for the sexual abuse all of you suffered, are they paying enough for that? The current plan says $500 million of cash and property. I think they're telling us they have about 400 million in cash, so maybe about 100 million of property, and another promissory note for $100 million. Is that enough to get the local councils released from their liability? We contend it is not. We believe the local councils have a lot more that they could spend to satisfy your abuse claims and still be financially viable in the future. And those were the dashboards we talked about last week. And we are working on trying to get the final dashboard, the dashboards finalized. But we do contend, and by the way, the dashboards have been shared with all the local councils, been shared with the Boy Scouts. We believe the number is multiples of what they're putting in. The similar, and I'll finish with this, John. There's a similar issue regarding the charter organizations. Under the current plan, the charter organizations for claims that are after January 176 are not required to put up $1 to satisfy those post-January 1, 1976 claims. The only thing they're required to do is to allow their insurance to be, let me step back. The charter organizations, insurance policies have insureds, right? You know, I buy a homeowner's policy, I'm an insured, and my name is on the policy. But deep in the policy, it says, and Jim's family, and Jim's cousins, and Jim's dog. Those are what we call additional insureds. They're not named, they're just referred to. The charter organizations argue that they are additional insureds under Boy Scout policies. They claim they are additional insureds under local council policies. If you read that real fine print, they say, hey, that's us. We're not named, but that's us. So under the settlement, the charter organizations are not putting in $1 of cash for the post-January 176 settlements, but they are allowing the insurance to flow through. We don't think that that's enough. We don't think that constitutes a contribution that justifies the charter organizations getting off the hook for the sexual abuse you all suffered. So that was a little technical, and I'm sorry, but those are the major issues the court's looking at. Voting and whether or not the contributions are sufficient to the settlement trust.
Thanks, Jim. I think we're going to go ahead and wrap up. I'm going to say a few things, then turn it over to you, Doug, to sort of close us out. So remember, vote. This is your chance to express your power. The only power, frankly, you've got left is to vote. And keep in mind that our modifications to the existing plan will include more independent oversight of youth protection. We'll address what Jim talked about, which is more money from local councils, sponsoring organizations, and insurers. And the third would be independent trustee and better trust distribution procedures. We feel very strongly about those things. We don't really think we're that far off, and that's why we need to reject the plan. So hang in there. Holidays around the corner, the 14th. The votes have to be in the possession of Omni by December the 14th. So if you're sending it by snail mail, you're competing with Christmas cards and holiday cards. If you're doing it electronically, you never know what things go up and down in the night. So do it soon enough so that it gets counted. Doug?
Thanks, John. Hey, John and I want to give a special shout out tonight to a member of the TCC. Wade Paul is a retired veteran, and it's Veterans Day. And, I also heard from a veteran this past week that served tours in Afghanistan. And, John and I suffered, all the effects, like a lot of us, being survivors and after being abused. And I can't begin to imagine what it must have felt like for many of you that are veterans to not only serve, but also deal with your consequences. So on behalf of John and I want to thank one of our own on the TCC, Wade Paul. I know John Lucas and Jim Stang agree. We all just want to say thank you to all of you veterans who have, served double duty, being a survivor and also a veteran. So thank you for your service, everybody.
We appreciate it a lot. You guys have a really good evening. Thanks for coming.
Stay strong, everyone.